Hello students, today's topic of discussion is justice delivery system under the criminal laws. In all societies, from the underdeveloped to the most modern ones, there is law in one form or the other. State uses law as an instrument for delivering justice. So, law and justice are closely connected with each other. Criminal law is that part of the law which deals with the definition, punishment of crime, and with the procedure for trial of persons suspected or accused of crime. Criminal law ensures administration of justice by protecting and enforcing the rights of the individual and by punishing the wrongdoer, and thereby it maintains the law and order in society. It has been observed in 37th report of the Law Commission of India that criminal law is an instrument for the protection of society, having criminal procedure as its chief means and criminal courts as the main agencies for its administration. From time to time, the state frames various substantive and procedural criminal laws for the administration of criminal justice. Now let's talk about what actually is the criminal justice system. It refers to the composition, function and decision making processes of units that deal with crime prevention, investigation, prosecution, punishment and correction. It is an amalgamation of agencies which, though independently funded, managed and operated, ensure justice jointly but by functioning within the respective spheres assigned to them. Criminal law secures justice by protecting and enforcing the rights of the individuals and by punishing the wrongdoer. The procedure of administration of criminal justice in our country is divided into three stages, namely investigation, inquiry and trial. The Criminal Procedure Code 1973 provides for the procedure to be followed in investigation, inquiry and trial for every offence under the Indian Penal Code or under any other law. Now let's talk about the criminal justice delivery process. In the process of delivering justice, there are three stages, namely investigation, inquiry and trial. Investigation is the starting point where the system gets into motion. It is conducted by the police and usually starts after the recording of a first information report, or shortly it can be called FIR, in the police station. Section 156 clause 1 requires the concerned officer to investigate the facts and circumstances of such a case without any order from the magistrate in this behalf. The investigation procedure ends with the submission of a police report to the magistrate under section 173 of the Code of Criminal Procedure. This report is basically a conclusion which an investigation officer draws on the basis of evidence collected. Now the second phase is inquiry, dealt under section 177 to 189 of the code, which is conducted by a magistrate either on receiving a police report or upon a complaint by any other person, being satisfied of the facts. Lastly, the third stage is trial. Trial is the adjudication of a person's guilt or innocence. Under the Code of Criminal Procedure, criminal trials have been categorized into three divisions having different procedures called warrant, summons and summary trials. If we talk about the functionaries of the criminal justice system, the criminal justice system has 5 important components in India: the investigating agency, the prosecution, the defense lawyer, the judiciary, and the correctional services. The investigating agency, that is police, connotes a body of civil servants whose primary duties are preservation of order, prevention and detention of crimes, and enforcement of the law. The basic duties of the police are to register cases, investigate them as per the procedure laid down in the Code of Criminal Procedure 1973, and to send them up for trial. Then comes the prosecution. Public prosecution is another important component of administration of criminal justice system. Since crimes are committed against the state, therefore, in a criminal case, state takes initiative to prosecute the accused and to bring the offender before justice. For this purpose, state appoints prosecutors. Section 2, Clause U of the Code of Criminal Procedure 1973 defines public prosecutor as any person appointed under Section 24 and includes any person acting under the direction of public prosecutor. He is legally responsible for presenting the case against an individual suspected of breaking the law in a criminal trial. Since crimes are considered to be doing wrongs against the state, therefore, criminal prosecutions are initiated by the government through the help of public prosecutors. It is important to mention that only an independent and impartial prosecutor with the highest degree of morality can protect the right to fair trial of the accused and thus plays an important role in rendering justice. Now comes the defense counsel. A criminal defense lawyer, also known as a defense attorney, is a lawyer specializing in the defense of individual charged with criminal conduct. Some criminal defense lawyers are privately hired, while others are employed by the various jurisdictions with criminal courts for appointing to represent the indigent persons. In Menka Gandhi versus Union of India, it was held that the right of an indigent person to be provided with a lawyer at state's expenses is essential ingredient of Article 21 of Indian Constitution. For no procedure can be just and fair which does not make available legal services to an accused who is too poor to pay for a lawyer. In Khatri versus State of Bihar, the Supreme Court held that the mandatory obligation of the state to provide free legal aid arise in every criminal case against an indigent accused. Again in Sukhdas and others versus Union Territory of Hrl&Cj Pradesh, it was held that the right to get free legal assistance at the cost of state is a fundamental right of the accused, which cannot be denied on account of failure of the accused to make an application for the same. Now I'll explain you the various types of criminal courts in India which plays a very important role in the delivery of criminal justice. The modern judicial system operating in India for the administration of criminal justice basically comprises four categories of courts: the Supreme Court of India, High Courts, Session Courts, and the Court of Magistrates. So far as the criminal cases are concerned, the Supreme Court is empowered to exercise appellate jurisdiction only as per the provisions under Article 132 and Article 134 of the Constitution of India. Article 227 of the Constitution gives the High Court the power of superintendence over all courts throughout the territory of a state. The court confers upon the High Court various powers, including those relating to reference, appeal, revision, and transfer of cases. It also provides specifically the inherent powers of the High Court to prevent the abuse of the process of any court or to secure the ends of justice under Section 482. The court confers power upon the session judge to conduct trial and punish the offender accused of serious offences. Various provisions regarding appeal, revision and transfer of cases have also been the first class may pass a sentence of imprisonment for a term not exceeding 3 years or of a fine not exceeding 10,000 rupees or of both, and the court of the magistrates of the second class may pass a sentence of imprisonment for a term not exceeding 1 year or of a fine not exceeding 5,000 rupees or of both. Now I'll explain you the provisions regarding the criminal appeal. In criminal cases, an appeal provides an opportunity to the higher court to make a scrutiny of the record of the trial proceedings to determine if a legal error occurred that may have affected the outcome of the trial or the sentence imposed by the judge. The Code of Criminal Procedure 1973 provides when an appeal can be filed and specifically prohibits that no appeal shall lie from any judgment or order of a criminal court except as provided by this code or by any other law. There are large varieties of cases providing criminal appeals. I'll explain you the circumstances under which appeals can be made to various courts. Appeal to Session Court. Any person convicted on a trial held by Metropolitan Magistrate or Assistant Session Judge or Magistrate of the first class or of the second class may appeal to the Court of Session. Any person sentenced under Section 325 may appeal to the Court of Session. Similarly, any person in respect of whom an order has been made or a sentence has been passed under Section 360 of Code of Criminal Procedure by any magistrate can appeal to the Court of Session. Now we'll talk about the appeal to the High Courts. Any person convicted on a trial held by Session Judge or an additional Session Judge or on a trial held by any other court in which a sentence of imprisonment of more than 7 years has been passed against him or against any other person convicted at the same trial may appeal to the High Court. Now lastly, an appeal to the Supreme Court. An appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court in the territory of India. If the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death, or certifies under Article 134A that the case is a fit one for appeal to the Supreme Court. The Supreme Court may in its discretion grant special leave to appeal from any judgment, decree sentence or order in any matter passed by any court or tribunal in the territory of India. However, the above rule will not apply to any judgment, determination, sentence or order passed or made by any court or tribunal constituted or under any law relating to the armed forces. Now I will talk about how the correctional services are providing important role in the delivery of criminal justice system. Today, the main objective of the criminal justice administration is not merely to punish the offender, but to reform the offender to make them fit for the society through the correctional agencies. The correctional services mainly consists of probation and parole. Probation is such a treatment device which aims at rehabilitation of the young offenders by returning them to the society during a period of supervision, rather than by sending them into a unnatural and unhealthy atmosphere of prisons. Probation is a non-institutional method of dealing with corrigible offenders, particularly the young and first ones, by allowing them to remain in the community and to develop in a healthy manner as a normal human being in their own natural surroundings. To conclude, we can say that though the decision in Maneka Gandhi versus Union of India has introduced some changes in the criminal justice system, still the position is far from being satisfactory. There is sharp rise in crime rates in today's society, and as a result of which the criminal justice system is being overburdened with cases. The main reason behind this is the criminal justice system is more procedural and technical, with a low rate of disposal of cases. Therefore, on many instances, rendering of justice is being delayed, shaking the people's faith in the administration of criminal justice. Therefore, it is very much essential that the conventional criminal prosecution and settlement of cases should adopt certain elements of alternative dispute resolution for the purpose of making it more simple and fast enough, and at the same time less costly also, without losing its deterrent value. This will ensure speedy trial, which is the essence of an efficient criminal justice system and which ultimately implies speedy access to justice.